we made an appeal to nature and nature's God to claim independence, and that our inalienable rights exist prior to government because they're gifts of a creator. None of that's possible under the modern separation view, and we completely destroy the foundation for our entire constitutional system.
Let's talk about one particular area of constitutional law, church and state, or the First Amendment in its bearing on religion in America. How did the framers of the First Amendment understand it? And that will lead, of course, to another question: how do we understand it today?
Yeah. I think the framers understood it largely as a federalism provision. I mean, you have to remember, we had 13 different states that were forming this new nation, and each of them had different relationships with religion. One of the core powers of the state governments was what we call the police power, the power to advance or to regulate, enhance the health, safety, welfare, and morals of the people. Mm-hmm. And I think they were all of the view that in order to have a self-governing democracy, you had to have a moral citizenry. And Washington tells us in his farewell address, we would be foolish to think we could accomplish that without a heavy reliance on religion. The only question was whether you were going to have a one religion fits all state church, which had led to disastrous consequences in Europe, and quite frankly was more responsible for the American founding than anything else. And so they wanted to prevent the national government from having a national church because it would stifle the thriving relationships between state governments and religion.
And is that because it would violate free exercise,
well,
or because it would implicate government in a way that would be bad for government and bad for religion?
Well, I think they didn't want to keep government out of religion. They wanted to keep the national government out of it because they recognized that this intricate relationship between government and religion would be different depending on the different regions and the different cultures and the different habits of the people. Virginia was different than Massachusetts. And they wanted to let the states free to experiment with how best to foster that moral citizenry without having one rule done nationally that would be imposed everywhere. Mm-hmm. And so the first proposals Madison offers, so there shall be no national church. And in the first Congress, opposition to that was that's not protective enough of religion in the states. Mm-hmm. Well, because there were lots of ways that Congress might interfere with state support of religion.
Right, and just to make clear, in 1787, the Congregational Church is the established church of Massachusetts. The Anglican Church had maybe recently been disestablished in Virginia, but only very recently.
Right.
But there were established churches in many of the states who in 1787 had written the Constitution for themselves and who were now in Congress deliberating on the First Amendment.
Right, and they did not want the federal government preventing them from continuing. And even in the states that didn't have established churches, there was a healthy relationship between religion and the state. I mean, the church hall was often the community center. It was the school. It was the city hall. It was the communities were formed around the church. The first building erected was often the church in these towns, and they didn't want the federal government interfering with that. And having a national church would interfere with it if your support of religion was not that designated church. Right. But they rightly recognized there were lots of other ways that Congress, through its enumerated powers, might interfere with religion in the states and therefore undermine these efforts to have a moral citizenry. Mm-hmm. And so the language was changed. No law establishing a national church, no law respecting an establishment of religion that would either create a national church or otherwise interfere with it. And that meant that there would be a healthy flourishing of religion in the states, just not at the national level. And it was part and parcel of the other limitations on government. We gave to the national government only those things that only the national government could do: interstate commerce, international commerce, foreign affairs, war-making power, coining of a uniform currency. Everything else was going to be done in the states. the fostering of the basic health and safety and morals of the people. And in that enterprise, we wanted to be able to rely on religion.
Now, let's investigate that a little bit. So your view is that the prohibition on establishing a religion is peculiarly and only a prohibition on the national government from establishing a national religion. It would have in no way touched the state establishments. If a state wanted to have an established church, it could continue to have, and did continue to have, of course, an established church long after the First Amendment was passed. The final one was disestablished in, 1833 or 4 or something like that.
In Massachusetts.
Massachusetts. But the same kind of reasoning that cut against a national church, would that have cut against an exclusive, a strong established church within one of the states? I mean, there was a difference between American establishments, even in Massachusetts, and the European ones that had precipitated the wars of religion that you referred to earlier. I mean, our establishments tended to be more liberal. Often, in the case of Virginia, the establishment meant you could contribute taxes. You had to contribute taxes to the church of your choice, among at least a menu of them, not to a church that was not of your choice. I mean, is there some indirect liberalization of establishments, even on the state level, from the same ideas?
Yes, they were going on at the time. I wouldn't call it a more liberal view of it. I call it a less coercive view.
Mm-hmm, okay.
So the hardline establishments started falling immediately. That I could force you not just to support the state church. Mm-hmm. Right? I mean, I force taxpayers to support all sorts of things they disagree with, and I've made the judgment that a state church actually advances societal goods. The states were able to do that. That fell fairly quickly, though. But even harder than that was I could force you to accept the beliefs mm-hmm. and to acknowledge them as a condition of voting, as a condition of holding office. Mm-hmm. Those fell fairly quickly because it became very evident that they violated your own freedom of conscience. But see, that you could have an established church that would remain viable, consistent with free exercise if you took out the coercion piece.
Right.
And what translated that into the broader fight we have now is coercion meant if I tax you to support any
right.
religion, and
right.
that gets us into a different direction.
Yeah, so I mean, George Washington, to whom I think you referred, his position was in a way that religion was a public good because it encouraged morality, which is a public good, and therefore even if it's as a means to an end, it is part of a sort of public good. And the business of government is to provide public goods, whether they're roads and bridges and canals, or a certain moral order in the souls of the citizens of the Commonwealth. That's a little bit different from establishing a religion because you think it's true religion,
right?
And other religions are false religions. And in your view, in the American case, are we talking about which kind of establishment? Out of true religion, or of many religions, each good enough to secure the public good of morality?
I think for Washington, the notion that it was a public good is more indicative of the founders' views more broadly. Mm-hmm. And of course, that means that some places will adopt one religion as the true religion,
right.
and derive the public goods from that. As long as you have an exit option
yes.
to go to another town or another state to have a different view, that plurality of religious outlook would flourish, and we would derive the public good out of it. Mm-hmm. And so, for example, Congress passes the Northwest Ordinance, and they say in it, knowledge, religion, and morality being necessary for good government,
right.
schools and the means of education shall forever be encouraged. Well, I mean, religion is in there as the direct predicate of establishing the school systems
right.
in all of the Northwest states that were found. And the townships were laid out under the Jeffersonian model, mm-hmm. where the central parcel in the township was going to be reserved for religious purposes, and another parcel reserved for educational purposes. This was directly supported by government, and yet without the coercive aspects, and so whole congregations would move to a township, and that one would form around one church. and a different congregation of a different denomination would found a different township in another part of Ohio. And this was the way it established, these were established churches in the towns with an exit option if I didn't like that church, but I derived the public good from it without coercing anybody. The two existed simultaneously.
But you're hewing to the line that taxation is not coercion.
I am.
Yeah.
I am. Any more than taxation of me to support the military adventures in Iraq or Afghanistan, if I disagreed with those, is something I can reject because it's the public good we all share in. And Jefferson had a different view. All right. What's happened is that Jefferson's view, which was an outlier, has become the main driver for the interpretation of the First Amendment. I think that's ahistorical.
But didn't Madison have a similar view?
Madison had a similar view in the state of Virginia, but I don't think it's reflected in what he pushes in the First Amendment.
Yes, not nationally.
Yeah,
That's
yeah,
true.
yeah.
All right, now, so how did we get, and what is the current view of the establishment clause?
So a couple of things that everybody agrees on. The First Amendment does not apply to the states directly, which meant it was a limitation on the national government. We get the 14th Amendment after the Civil War, and gradually over the next 50 years, a number of provisions of the Bill of Rights start applying to the states via the 14th Amendment. We call that the incorporation doctrine. Right? And liberty, the 14th Amendment protects us in our liberty without due process of law from state infringement. Right? Well, my free exercise of religion is a liberty, and that was naturally incorporated. Right? It's just like the free speech, my Second Amendment rights, my right against self-incrimination, we've incorporated all of those and made them applicable to states. The Establishment Clause, this federalism idea of it that I talked about earlier, doesn't lend itself to that. And yet the Supreme Court in 1947 just says, well, we've incorporated the Free Exercise Clause, we should incorporate the Establishment Clause too, without any reasoning other than we'd already done the other clause. And it's a different in kind. And they did two twists there. They said if it means anything...
This is the Everson case.
The Everson case. If the First Amendment Establishment Clause means anything, it means this, that neither the state nor federal government shall establish a church. Well, that was new. They never said the state government shall establish a church, shall provide aid to one religion, all religions, or prefer one religion over another. And they never said any aid to all religions. And so we then create this separation, not between a single sectarian church and government, but religion and government, and that lays the groundwork for the modern view of complete separation of church and state.
Now, is there any sense in trying to revive the original understanding of the Establishment Clause at this point? I mean, most of the religion cases turn on the latter part of Everson, which is whether or not government can support religion in all, to what extent, and so forth, rather than, there aren't many people arguing for an established church anywhere.
Right. One of our great successes at our Center for Constitutional Jurisprudence was to revive the discussion that the Establishment Clause was a federalism provision. Now, there's no state in the country that's going to reestablish a church, but there are many states that would be more actively engaged with religion in schools, in the public square, than modern Supreme Court interpretation has allowed them to be, and I think that would be healthy, and so we have reopened that discussion. But here's how bizarre it has become, all right? When you say you can't have a established church, you can't have the Anglicans and everybody forced to pay taxes to the Anglicans and then everybody forced to accept their beliefs or not hold office or vote, right? When you say, well, it's not just that, but it's any reference to religion or God, right? Now think about how profound that is for a system grounded on the immutable truths of the self-evident truths that we're all created equal, that we made an appeal to nature and nature's God to claim independence, and that our inalienable rights exist prior to government because they're gifts of a creator. None of that's possible under the modern separation view, and we completely destroy the foundation for our entire constitutional system.
But I guess the practical question would be, is it easier or harder to have a friendlier relation between religion and the public square by saying, of course, establishment is impossible, off the table, nobody would dream of arguing for establishment. But this is not establishment. This is religion as a public good, and very nothing in the way of coercion attached to it. Or is it easier to say, we could have an established church, and we don't really want one right now, but we do want this kind of closer relationship between the public square and religion. Doesn't that make the argument harder than the prior assumption?
It does. And Justice Thomas has, I think, skirted that issue very well in his opinions on this subject. He said an establishment that itself became coercive would violate not only the Establishment Clause, but the Free Exercise Clause. Mm-hmm. And you know, even if the Establishment Clause is not properly incorporated, the Free Exercise Clause is. And so we're not talking about going there. But we are talking about the ability of a city council to begin with a prayer, legislative prayer, just as all of the founders did. Mm-hmm. We are the ability to have a Christmas tree, to acknowledge our heritage. The ability to read the Declaration of Independence is something other than just a historical document that you got to gloss over some of that language and actually teach it that there's something really fundamental about our relationship with God that defines why we have rights that exist prior to government. And if we can't teach that with reference to God or religion, then it seems to be a pretty odd slate we're trying to write on.
Right. Freedom of religion is easier with God than without.
It is.
Or against Him.
Well, we recently asked the court to revisit some of the main jurisprudence in this area, and involving the Mount Soledad cross. Mm-hmm. And our closing paragraph in the brief was, this is a cross that's part of a war memorial. It overlooks the city of San Diego, named after the Catholic saint San Diego de Alcala, whose mission was the founding of San Diego. It sits in a state of California, whose state capital is Sacramento, Spanish for the sacrament, with a constitution that says we acknowledge a duty to God, that forms part of a nation that was, designed with an appeal to nature's God. Right. That if the cross is unconstitutional, then probably the city name, the state capital, the state constitution, and the Declaration itself are. We've probably gotten off track someplace.